Hello?
Let me mute again, but I don't have anything going.
Okay.
Yeah, that helps.
Yeah,
Here's Kevin.
all right, Kevin, have a seat.
Good morning, Your Honor.
Good morning. Who is Miss Carrillo?
That's Katrina in pretrial.
Oh, okay. Yeah,
She's been my.
sorry, I never knew her last name.
She's been my savior.
All right.
Oh, she's been my savior.
Can you hear us okay, Kevin?
Yes, sir.
Okay,
She's been, Miss Katrina has been awesome.
all right, all right. Now, when you talk, I need you to speak up and sit still because it's kind of hard to hear you from there,
I
okay?
understand, Your Honor.
All right, thank you.
You're welcome.
All right. Anything we need to take up before we, before I call the case?
Judge, I did file that motion, but I think it's no longer necessary. So we don't need to, I'm withdrawing my
Oh.
motion.
You mean not the motion for departure, but the motion to withdraw?
Withdraw, yes.
Okay, all right. And Mr. Rogers, I know there was, after our last hearing, you were expressing some displeasure. Do you want to proceed with Mr. Russo as your attorney today? Okay. All right. Then I'll go ahead and call the case and we'll get started.
Yes, sir.
Calling case number 2020-CR420, captioned State of Kansas versus Kevin Rogers. Would the parties announce their appearances, please?
May it please the court, Assistant District Attorney Bianca Finney on behalf of the state of Kansas.
May it please the court, defendant appears in person by Zoom with counsel Anthony R. Russo, also by Zoom.
All right. We are here set down for a sentencing. The parties were in court on August 31st, at which time the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted that, ordered a pre-sentence investigation, and set it for sentencing. We've had to continue this a couple of times, but we're ready for sentencing today. I've received and reviewed that pre-sentence investigation. The critical findings are as follows. The primary count of conviction is one of burglary, which is a severity level 9 non-person felony. The defendant's criminal history score was found to be that of A, as in Adam. That would leave him with a presumed sentence of prison with a presumed range of 15, 16, or 17 months. If he has to do that time, he'll be eligible for 20% good time credit and subject to post-release supervision duration of 12 months. If he's granted probation today, it would be for a period of 12 months to community corrections. A special rule also applies to this case, and that being that special rule number 10, which is this was a crime committed while on felony bond. This second count of conviction is one of criminal damage to property. That is a severity level 9 non-person felony. For scoring purposes, defendant is considered a criminal history I. That would leave him with a presumed sentence of 5, 6, or 7 months, again with a presumption of prison. The same 20% good time credit, 12 months of post-release supervision duration, 12 months of probation, and special rule apply to those. I would ask you first, Ms. Finney, did you have an opportunity to review the pre-sentence investigation? Do you have any additions, corrections, or challenges to those findings?
I have reviewed it, Your Honor. I have no additions or corrections.
Mr. Russo, same question.
Judge, I did review it with my client, and we have no challenges to the criminal history score of A and no additions or deletions.
All right. I will adopt the findings of the pre-sentence investigation, given no challenges there too. Mr. Russo, you filed a motion for departure. Would you like to be heard on that this morning?
Yes, Judge. Just basically that my client did accept responsibility. He did not make the state prove his guilt beyond a reasonable doubt, which he had every right to do so, therefore saving the state time and money and accepting responsibility. So we do believe that substantial and compelling reasons do appear that
Hold on. I think
Judge,
you're.
sorry. You froze up on me, Tony. It says, so we accepting responsibility, so we do believe that.
Substantial and compelling reasons do exist for the court to depart.
All right. Ms. Finney, your position on Mr. Russo's motion.
The state has no objection to Mr. Russo's motion. We are comfortable, if the court is comfortable, allowing him to be put on probation.
All right. Mr. Rogers, now's your opportunity to tell me anything you want me to know before I pronounce sentence today.
One thing I want to know is, I remember that morning.
I'm sorry, I didn't understand.
It's very
Start
hard to
over,
hear you,
please.
Mr. Rogers, so speak up nice and loud because we have to take down everything. Speak up nice and loud, sit still so that Ms. Zarate can get what you have to say on the record, okay?
Right. I really don't have much to say, is that I remember that morning when that happened, and I don't even know why I was even there doing whatever I was doing. I don't even remember doing it, but what I did, and so that's it. And I plead guilty.
Thank you, Mr. Rogers.
Yep.
All right. Mr. Russo, do you know any legal reason why I should not now proceed to sentencing?
No, Your Honor.
All right. I'm going to craft something here. I'm going to grant the defendant's motion, find substantial and compelling reasons. The original plea petition or plea agreement was that he was to get the mitigated box and no other departures. Since that's been modified, I am going to grant the departure. I'm going to find substantial and compelling reasons, given what Mr. Russo had to say, and the court's belief that this crime is a result of the defendant's a couple of things going on in the defendant's life, his drug addiction and his mental health. And I do believe that there are services and programs available for the defendant that are going to serve defendant reformation better than a prison sanction. So I'm going to grant that departure. However, given that, I'm not going to pick the mitigated box today, and therefore the defendant will be sentenced to a period of 16 months in the Department of Corrections. If he has to do that time, he'll be eligible for 20% good time credit and subject to a post-release supervision duration of 12 months. His application for probation today is considered and it is granted to community corrections for 12 months. As to count 2, the defendant will be sentenced to the standard range of 6 months. That will be ordered to run concurrently with count 1. Again, eligible for 20% good time credit and subject to 12 months of post-release supervision duration. His probation on count 2 is also granted to community corrections for a period of 12 months. A specific term of the defendant's
Sorry, Judge.
Yep.
His probation on count. That's where I stopped.
his application for probation as to count 2 is also granted to community corrections for a period of 12 months. A specific term of his probation will be that he obtain a substance abuse evaluation and follow the recommendations, as well as a mental health evaluation and follow those recommendations. Obviously, he has case management at the Wyandotte Center, so I believe he's had those evaluations, or at least the mental health. He won't be required to get a new one as long as he is following the recommendations of his ongoing evaluations. Given Mr. Rogers' unique position as far as addressing substance abuse and mental health, I don't believe that he's going to have the financial wherewithal to meet financial obligations. Therefore, I am going to waive court costs and supervision fees. I'm also going to waive Mr. Russo's fees as appointed counsel. He doesn't need to, I'm sorry, Mr. Russo, were you retained?
I was retained, Judge.
You were retained, I'm sorry. He doesn't need to pay a database fee because he's already in the Kansas database per the pre-sentence investigation. let me make sure that that is correct. Is he,
I was looking at that too.
oh, you know what? These are not, none of these are Kansas convictions. So that payment is required, cannot be waived. So I am going to impose the DNA database fee. But that would be it. All right. Mr. Rogers, you have 14 days from today to appeal anything you don't like about your sentence. You also may be able to seek expungement after a period of time following successful completion of probation. As a convicted felon, it's prohibited for you to own or possess a firearm, certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically knives that could be considered deadly weapons, okay?
What did you mean by expungement means? I understand what that word means. You mean after successfully completing my probation, then I can come back to you and ask for expungement?
You might be able to seek expungement, which means having it wiped off your record.
Right, and what period of time after my probation is successfully completed?
There are a number of different elements that go into that. If you're truly interested in that, speak with Mr. Russo when we're done here, and he can maybe get you to put it on your calendar and schedule a time after you get off probation that you'll be eligible for that, okay?
I can deal with him with that.
All right.
All right, Judge. He can
Yep.
get you to put it on your calendar.
Have Mr. Russo talk with him. You can put it on your calendar for a time you might be eligible, you could file.
And then, so is Mr. Russo going to be my attorney through the entire, until I'm done?
No, well, that's between you and he, okay? Oftentimes attorneys get out at sentencing, particularly retained attorneys.
Well,
If you want to keep him on, I don't know, you can talk to him about that, see what it would cost.
right. And if I don't have the money to keep him, could he be court appointed?
Well, as soon as this case is we're done sentencing, your
Yeah.
case is considered over here. If you face a probation revocation hearing in the future, we can take it up at that time. You can choose whether or not to retain Mr. Russo at that time or request that the court find you indigent and appoint an attorney. All right, but you're not going to be needing an attorney right now because you don't have a case pending in court.
Okay.
If you do want to, I urge you to keep in touch with Mr. Russo. If you need further guidance, obviously that might cost you, but that's between you and he.
Okay.
All right. Ms. Finney, anything else we need for the record today?
What about probation?
Just one moment, Judge. Give me just 1 second.
Okay.
What about probation? Who do I report to?
I'm going to tell you that here in a second.
Okay.
Sorry, my computer's running really slowly this morning.
It's okay.
No, Your Honor, you've covered everything.
All right, Mr. Russo.
Nothing by the defendant.
All right,
Except for the
Mr.
probation part.
Mr. Rogers, do you have something to write this down with?
Yeah, go ahead. She's gonna write it now. Go ahead. What is it?
You're going to call Community Corrections.
Community corrections.
The
Yeah.
number is 913
Mm-hmm.
573 4180. I'm going to send your paperwork over to them right now. Just tell them who you are, that the court instructed you to call over. They will tell you what to do.
Do I call today?
Yes.
Okay. Where's Miss Katrina at? Did she show up?
Who's that?
Miss Katrina.
Miss Katrina's here.
Oh,
Yeah.
okay. I didn't know where she was
She
at.
just has her camera off.
I just didn't see it.
All right.
She's been an
She will,
instrumental.
I don't think she'll need you to report to her anymore.
Yeah.
She may give you a call and let you know.
Okay.
Okay.
All right. Thank you.
All right. Anything else for our record today?
Nothing from the state, Your Honor.
Nothing
We
from the
are
defendant.
adjourned. Thank you, everyone. Good luck, Mr. Rogers.
Thank you, sir.
Thank you, Judge.
Mr.
Thank you.
Caruso?